Welcome everybody here to AI and white collar crime enforcement trends, AI washing liability, and building a compliance framework. I'm Mark Hogue, chair of the Beverly Hills Bar Association's AI in the Law section, along with my co-chair Amanda Harris. I'm also the founder of HogueLaw.ai, where I serve as fractional GC to AI first startups and SaaS companies while spending most of my nights and weekends vibe coding apps and other projects because of course I do. I am delighted to introduce today's speakers, Jennifer Park, Matthew Yelovich, and Christian Granger from Cleary, Gottlieb, Steen, and Hamilton LLP. So Matthew is a partner at Cleary Gottlieb, where his practice focuses on government and international investigations, defending companies and individuals in high-stakes domestic and international enforcement actions. Before joining Cleary, he served as Deputy Chief and Appellate Chief of the Criminal Division in the U.S. Attorney's Office for the Northern District of California, where he oversaw approximately 100 federal prosecutors. As an assistant U.S. attorney for nearly 10 years, he prosecuted corporate fraud, healthcare fraud, money laundering, and public corruption matters. He's clerked for the Honorable Rena Raggi of the U.S. the U.S. Court of Appeals for the Second Circuit, and has taught at Stanford Law School and UC College of the Law in San Francisco. Jennifer is also a partner at Cleary Gottlieb, where her practice focuses on white-collar defense, enforcement actions, crisis management, and complex disputes. She advises global corporations and financial institutions on interactions with regulators, including the DOJ, SEC, CFTC, and various international authorities. She's been recognized by Benchmark Litigation, Chambers USA, and Global Investigations Review, among others, and has published on DOJ compliance guidance updates addressing AI. She serves on the boards of Legal Services New York City and George Mark Children's House. And Christian Granger is a litigation and enforcement associate at Cleary Gottlieb, and prior to joining Cleary Gottlieb, Christian served as a legal scholar with the SEC Enforcement Division in San Francisco and has also extended to the District of Nevada. Christian earned his JD from the University of California, Hastings College of the Law, now UC Law SF, where he served as senior production editor of the UC Law Journal and was named champion of the David E. Snodgrass Moot Court competition. His recent publications include the Whistleblowing in Focus series, covering developments in whistleblowing laws and AI. And breathe. And with that, let's get started.
Well, thanks very much, Mark, for that generous introduction, and just pleasure to be with all of you today. Thank you to the Beverly Hills Bar Association for having us. We are going to talk today about artificial intelligence and enforcement actions. In particular, we've seen a real shift over the last few years in terms of how the federal authorities think about AI, and we're still seeing a lot of uncertainty as to how that plays out. So we're going to walk through sort of where we were, where we are now, and where we expect to be, as well as some practical advice that can help for those of you who are in-house or who are advising corporate clients on compliance programs in this era of uncertainty. So our goal at the end is that you'll walk away with a firmer understanding of both the recent history in terms of executive actions on artificial intelligence and the enforcement landscape, and sort of to-do list items for making sure your compliance infrastructure is up to snuff on that front. Next slide, please. So part of the presentation today is going to be walking through these areas. First, recent AI enforcement, and that will cover different examples of how federal authorities have been thinking about artificial intelligence in the enforcement landscape. We'll then talk about the Trump administration's approach to AI enforcement and some of the nuances that have developed there. We'll talk about AI enforcement tools, which is to say tools that federal authorities are actually employing in their cases in bringing enforcement actions and in running investigations. We'll touch on AI and privilege, which has become a recent news item in the last month or two, in particular, due to some court orders in one in enforcement action and then one in a civil action. And then we'll finish with building a compliance framework and some practical advice on things to make sure you're going through when doing that. If we have time at the end, we're happy to answer any questions. Next slide, please. And I will turn it over to my colleague, Jen.
Right. So when we say recent AI enforcement, I just want to preview that we're going to talk a little bit about what was happening under the prior Biden administration before the Trump administration took over. There are some things that the administrations have in common when it comes to AI, and then there are some stark differences between the two. So under the Biden administration, and then continuing somewhat Trump administration, both the Department of Justice and the Securities and Exchange Commission have focused on AI in sort of three distinct buckets that we're going to look at together. And those buckets are sort of enforcement buckets. So this is ways to think about how AI can be used potentially as part of a crime or as part of a regulatory offense that the SEC might be interested in. And roughly speaking, you can think about them in this way, which is, has the AI been used as sort of the weapon of the crime? Has AI been involved in a lie, right? So has AI enhanced the ability to lie? And lastly, has AI been sort of the object of a crime, meaning have you tried to infiltrate the AI technology? Just to drill down a little bit on that, when AI is the instrumentality of the fraud, what we're really talking about is hyperscaling crime using AI. And you'll hear the term hyperscaling used by folks within the Department of Justice and the SEC. So their view is that these are crimes we've seen before. They're fraud, they're price fixing, they're market manipulation, but AI allows you to hyperscale them. You know, think about your standard fraud against the elderly, for example. These sort of call up the elderly and try to get them to send money. Well, with AI, you can do that thousands or millions of times a day. Second category is the lie category. And this is what is referred to as AI washing. And this is where individuals or companies tell you something about their AI products or services that are powered by AI to attract customers, to attract investors. And that's just not true. And the last category is AI as the object of fraud, where, as I mentioned, AI is the target. So you're trying to steal someone's AI trade secrets or AI patented technology. Typically, these cases have a national security dimension, and we'll talk a little bit more about the current administration's focus on the national security aspects of artificial intelligence. We can go to the next slide. Thank you. So when we talk about AI as the instrumentality of fraud, I want to just focus a little bit on some statements that were made under the Biden administration by the Department of Justice. Lisa Monaco, who was the prior Deputy Attorney General, made a number of public statements over the course of 2024 about how the department was thinking about AI in the context of both white collar and non-white collar crime. And two important things come out of that. One is that she said that if you're going to use AI as an instrumentality of a crime, the government may seek to enhance penalties against you as a result. She even compared AI to a firearm, for example. So the Department of Justice can seek higher penalties when a firearm is used in a crime. And she said, AI is just like that. Use AI. We may decide to seek higher penalties because it poses a serious public risk. The second thing she said is that if a company wants to get credit from the Department of Justice for cooperating with it and or credit for having a robust compliance program, both of which are really important factors when the Department of Justice is considering whether to charge a company, how to charge a company, or how to resolve with a company, they're going to ask how your compliance program thinks about AI and addresses the risks of AI. So two ways in which AI comes up in the context of AI being the instrumentality of the fraud. So let's talk about an example. What does this look like actually in practice? And we can go to the next slide to do that. There we go. United States versus Smith. Super interesting case here. This is from September of 2024. I will say that this status is that this person has been indicted, and that hasn't gone any further yet. So no trial yet. So we'll see how this turns out. But the allegations are as follows: that Michael Smith decided that he was going to concoct a scheme to make money from music royalties. So he was going to both use artificial intelligence to create millions of songs, each of which had slightly different names on them. And I'll come back to why he did that. And he was also going to use AI-driven bots to listen to those songs on various streaming platforms. And the reason he wanted to use the bots to listen to the songs is that generates royalties. You get paid by these streaming services by the number of times a song is listened to. And so if you can get a song to be listened to millions of times, you're going to get more money. I'll come back to sort of now why he was changing the names. Mr. Smith allegedly knew that each of these streaming platforms had technology to try to detect fraud, and they would look at spikes in the number of streams of songs or number of streams that just seem unrealistic. So for example, a song has 1 billion listens in one day. Unless you're Taylor Swift or Beyonce, that's probably not realistic. And so he changed the names of each of the songs and had a limited number of listens to each of the songs. So again, this is actually just fraud, right? You made fake music to generate fake royalties, but you hyperscaled it with artificial intelligence. We'll follow this closely. I'd encourage people to pay attention to, if there's a guilty verdict, what the sentencing looks like, and if the government does in fact seek enhanced penalties because artificial intelligence was utilized. I think I'll turn it over to Matt now to talk about a different kind of AI crime.
Thanks, Jen. Next slide, please. Thank you. So another aspect of AI and enforcement is when AI was the object of the crime. And here is actually an area where I think both the past administration and the current administration are probably going to have a decent amount of overlap in their interest. And that is protecting American technology companies and American AI developers from economic espionage or IP theft that may occur, particularly that involving foreign actors. So here's an example case, United States versus Ding, which was charged in the fall of 2024 when I was still at the U.S. Attorney's Office by the U.S. Attorney's Office in the Northern District of California. And that case involved allegations that the defendant, who was a software engineer, had actually been slowly stealing AI technology from his employer and moving that those trade secrets to the People's Republic of China, to two different entities with which he was associated. The investigation of this crime was extremely fast for a white collar case. And I flag that because I think that that is a trend that you're going to see in cutting edge AI technology cases where the government is trying to protect the technology. I think there's every incentive for both the government and the private sector together to move quickly on cases like this. At the time, it was a case that was highlighted by the Attorney General of the United States. The indictment was announced by then Attorney General Merrick Garland at a conference for white-collar criminal lawyers. And, you know, his personal involvement in the announcement, it's very rare for an Attorney General to announce a federal indictment, I think signaled the last administration's interest in this type of case. But as I said, I expect that that type of enforcement interest will, has bipartisan appeal for the current administration as well. Unlike Smith, Ding has already gone to trial. He was convicted in January of 2026 of stealing trade secrets and of economic espionage, which is stealing the trade secrets with the intent of aiding a foreign country. Next slide, please. So another aspect, another bucket of enforcement actions that Jen mentioned at the start is AI washing. And like Jen said, a lot of these AI related cases end up being frauds that just the subject of the fraud is artificial intelligence. And so it's not that the AI, it's not that AI is an instrumentality to supercharge the offense, and it's not that AI is the object of the trade secret theft or any kind of crime. It's that AI is the subject of lies for companies who want to get more investments or want to retain investments and realize that as the entire economy shifts towards an AI-centric model across industries, there's every incentive to speak glowingly about the use of AI in your business. Now, the folks in these cases these are two example cases in United States versus Scale, charged in June and September of 2024. These two defendants, Scale and Junko. The defendant in Scale was ultimately pled guilty, whereas the defendant in the Junko matter remains just under indictment. But these are both classic examples of investment fraud. So, you have two individuals who, in soliciting investments from private persons, just lied about the AI capabilities of their company. So, for Scale, the claim was that they had digital employees that could replace 5 human employees and save your company $100,000 a year. And based on that statement, raised over $40 million in investor money. They falsely represented that the AI component would automate a lot of the work that your human employees were doing. And in fact, the founder also engaged in embezzlement against the company. So some side projects that didn't fare well for him. On Junko, this case was indicted in the Southern District of New York. It's still ongoing. There's another case where it was fraud to raise money. But the fraud was related to AI. So the owner of the company lied about the capabilities of the AI technology that the company was running, and said that they could match employers with diverse job candidates using 7 different AI algorithms, as well as a fully automated recruiting solution. In fact, the company had no such technology, but the company raised $21 million from 27 different investors. And so the allegations there, and I should say they are allegations because he remains indicted, are that the underlying technology actually wasn't anywhere close to what was being presented to investors. So these cases are, again, just illustrative, and I'm sure you'll see more of them going forward. And I know Christian in a moment will talk about AI washing in civil enforcement actions, but they're illustrative of the fact that you don't need complex technology to get an AI washing charge, right? I mean, you can have simple fraud that takes advantage of so much investor interest in AI technology and in the explosive growth in AI capabilities. And so, this is just another facet of how AI and the enforcement matrix are interacting. I will turn it over to Christian.
Thanks, Matt. As Matt previewed, MoviePass and Tadris Capital, for example, are 2 of the earliest AI washing enforcement cases brought by the DOJ, and show how the pattern of prosecuting AI-focused fraud was established before, as we'll talk about later, it became a stated priority. For MoviePass, in November of 2022, MoviePass's CEO was charged with securities fraud and wire fraud for misrepresenting that MoviePass's AI tools were capable of analyzing and monetizing subscriber data, when in reality, the company didn't have an AI-enabled platform. And then in January of 2025, the MoviePass CEO actually pled guilty to defrauding those same investors. So again, here the timeline is kind of noteworthy because the MoviePass conduct predates the current AI boom. AI washing cases aren't limited to just this generative AI era, and instead it appears that any misrepresentations about AI, whenever they occur, are fair game. Second example is Tadris Capital. So in September of 2023, Mina Tadros, the founder of Tadros Capital, was charged with wire fraud and investment advisor fraud. Tadros falsely represented that his fund used AI-driven algorithmic trading to generate guaranteed returns. But in reality, it was just a hedge fund. I mean, a Ponzi scheme run as a hedge fund using new investors' money to pay the promised returns. In February of last year, Tadros pled guilty to investment advisor fraud, and in August of last year, Tadros was sentenced to 30 months in prison. So there it was an AI washing on top of a Ponzi scheme, using AI-enabled investment claims as the hook, which made investors invest nearly $6 million, with less than 1% of those funds actually going to legitimate investments. They just funded exotic travel and luxury goods. If you wouldn't mind going to the next slide. Perfect. And then 3 civil examples. So Delphia and Global Predictions are 2 of the earliest AI washing cases brought by the SEC, and Presto Automation occurred just last year. So in Delphia, in March of 2024, the SEC fined Delphia $225,000. There, the firm falsely claimed, again, that it used AI to analyze client spending and social media habits to tailor their investment approaches and advice when no such data informed its investment practices, nor did they have the tools to back that up. And again, this is one of the first of the SEC's AI-related actions. Also, in March of 2024, the SEC fined Global Predictions $175,000. There, the firm falsely advertised that it developed an AI-driven investing algorithm that used client data to provide expert AI-driven forecasts. This was just a robo-advisor offering advisory services to retail clients, but in reality, it was not an AI-enabled platform, and they did not offer any tailored investment advice. And then a more recent example is Presto Automation. So in August of 2024, Presto Automation was delisted from the NASDAQ following a significant drop in its share price. And in January of 2025, Presto consented to a cease and desist order, cooperated with the SEC, who declined to impose any civil penalties, despite finding that the company made materially false and misleading claims in public filings and public statements in 2021 and 2023. There, the company claimed that its AI voice product eliminated the need for human order taking at drive-thrus, when the company was aware that most orders still required human intervention. And like the other examples that Matt and Jen covered, the statutory framework here is not novel. We're talking about wire fraud, securities fraud, and investment advisor fraud. None of these statutes mention AI, but all of them reach knowing misrepresentations made to obtain money or defraud investors. I think it's over to Jen to talk about the Trump administration.
Yeah, so before we turn to talking about the Trump administration, I just kind of want to summarize what you've heard, which is that, prior to the Trump administration, we had a Biden administration that was quite focused on the risk and dangers posed by artificial intelligence in particular spaces, right, to the everyday consumer, right, to national security, and to investors. And so the question in everybody's mind is, right, so what is the Trump administration doing around AI, and has the tide changed? Are we going in a different direction? I think what you're going to hear from us is the jury is probably still out on that question, but there's definitely at least been a tonal shift from the top about artificial intelligence. We're going to talk about some very specific executive orders that relate to artificial intelligence under the Trump administration. But before I do that, I just want to flag that there's a host of executive orders that have been issued by this administration that don't specifically relate to AI, but that ultimately could relate to AI. Let me give you an example. The administration now has executive orders relating to utilizing the False Claims Act to pursue government waste, fraud, and abuse. The False Claims Act is the statute that makes it unlawful to tell a lie to the government in order to procure a government contract. And one of the areas of focus for the government under the False Claims Act is lies related to artificial intelligence that led to the government giving you a contract or buying a service or product from you. So that's sort of a separate whole area of executive orders that aren't specific to AI, but that tangentially will relate to it. But let's turn to ones that are specific to AI. If we can go to the next slide. So this is an overview just of the administration's approach to artificial intelligence. What you'll see here is that there have been a series of executive actions that have outlined a vision for how AI should be governed at the federal level and what roles the state should play. There is a definite pro AI stance that comes into each of these executive orders. The underlying message is that America needs to lead when it comes to artificial intelligence in order to be competitive and to sort of win the AI war, particularly against China, but other countries as well. And that the government is going to use all of its various agencies to make sure that that happens. And so these orders cover the alphabet soup of executive agencies in directing the federal government to streamline bureaucracy so that artificial intelligence can advance more quickly, but also considering the risks of doing that to make sure we're protecting Main Street against those risks. So let's turn to the next slide. I'll talk about one of the executive orders. So first executive order we'll talk about is titled Removing Barriers to American Leadership in Artificial Intelligence. The title kind of tells you everything I think you need to know about the executive order. This is an executive order that laid out that the government was revoking the Biden administration's executive order related to artificial intelligence that was more risk-based and risk-focused, and was going to prioritize deregulation and eliminating bias against artificial intelligence and artificial intelligence training. It also said that there was going to need to be an action plan. So it directed a variety of different agencies to sit down, come up with an AI action plan. The AI action plan itself, which Matt will touch on in a second, I think is lengthy. And I would encourage the folks who have put comments into the Q&A to take a look at it, because it addresses some of these questions around how are we going to protect certain people from AI and what are our priorities around that protection. Matt, you want to take over?
Sure, thanks, Jen. In December of just this past year, the Trump administration issued yet another executive order, this one entitled Ensuring a National Policy Framework for Artificial Intelligence. This is really an effort to protect the growing AI industry from different state-by-state regulation. So the purpose of the order is to direct different parts of the federal government to do what it can to remove barriers to the AI industry's growth. And the barriers that the administration has identified are mostly regulatory in nature or the threat of state regulation, because as I'm sure you've all seen, there's been a lot of news about different states trying to think through what kinds of regulations might be appropriate for protecting consumers or others in their state. Most prominently, of course, California has had a very public debate about that. And the executive order tries to get in front of that by directing, to the extent it can, federal agencies to issue regulations and try and preempt state authority in this area. So in particular, I want to highlight that the executive order comes right out and says that it favors a minimally burdensome national standard. This is the kind of language that actually is pretty rare in a federal executive order, in that it so clearly takes a minimalist regulatory approach. It directs the FTC to issue a policy statement on the application of the FTC Act and how unfair and deceptive acts and practices, which are prohibited under the FTC Act, how that interacts with AI models and the growth of AI. We expect that will end up being significant for companies that are making AI-related marketing representations or representations directly to consumers, and it may give consumers and the FTC a roadmap for civil enforcement that might follow once the FTC acts. It also will probably be persuasive to courts when they're thinking about whether state laws that interpret similar language in state acts to the FTC Act's language, whether it applies to certain AI-related conduct. That may be informed by the FTC's own view of what the FTC Act involves. Similarly, and last point on this, the December executive order directs the Secretary of Commerce to issue a policy notice specifying the conditions under which states may be eligible for funding under the Broadband Equity Access and Deployment Program. I think in general, everyone's eyes are on the FTC on this, and I would not be surprised, and Jen and Christian can jump in if they disagree, but I would not be surprised to see more executive orders along the lines of what we've just described, because you've seen the pace and volume of those executive orders be quite high when it relates to AI under this administration. Next slide, please. Christian, I think you're on mute.
Thanks, Matt. So U.S. versus Sanager is the first AI washing case brought under the Trump administration. As Jen and Matt have both previewed, this is one of the common threads that's continued from the last administration until the present. And here the SEC and DOJ filed parallel actions. But on the DOJ front, in March of 2025, the U.S. Attorney's Office for the Southern District of New York charged Albert Sanager with securities fraud and wire fraud. The indictment alleged that Sanager raised over $40 million by claiming his shopping app, Nate, used cutting-edge AI. He claimed a 93 to 94% automation rate for a single-click shopping website and touted a custom-built deep learning model. In reality, the automation rate was stuck at 0%, and the transactions were processed manually by contract workers overseas. So Sanager instructed employees to keep overseas contractors secret, controlled information shared with investors, and expectedly, the company ultimately failed, leaving investors with near total losses. In December of 2025, Sanager pled not guilty to securities fraud, and the case is still ongoing. However, notably on a policy point, the prosecutors framed the Sanager case as promoting American technological leadership, stating that Sanager's misrepresentations and AI misrepresentations more broadly not only victimize innocent investors, they divert capital from legitimate startups, make investors skeptical of real breakthroughs, and ultimately impede the progress of AI development. And this framing is important because it's consistent with the lens that Jen described of Executive Order 14179, which is aimed at removing barriers to American leadership in AI, which includes ensuring that money is going to the trustworthy and noteworthy businesses that are not abusing or misstating their AI capabilities. So the government's not just prosecuting fraud, it's prosecuting fraud that threatens American AI competitiveness. And then I think it's over to Matt to talk about some enforcement tools that the U.S. is using.
Thanks, Christian. So we're going to touch briefly on how the federal government is actually using AI in its enforcement capacity. So I'll touch on two specific examples related to the Department of Justice's use of AI and the FBI's use of AI in their investigations and prosecutions. And then I'll turn it back over to Christian to cover the SEC and the Treasury Department's use of AI in their work. So the first thing I want to mention is the healthcare initiative. So in June of 2025, the Department of Justice announced that it had charged 324 defendants with healthcare fraud, totaling $14.6 billion, which is the largest healthcare fraud takedown in Department of Justice history. Obviously, these are huge numbers, and most of the time when these kinds of announcements are put together, there's sort of a scramble to find related cases that might be part of that initiative. But here, there was a through line in the announcement in that the head of the criminal division highlighted the use of the department's new tool, which is the Healthcare Fraud Data Fusion Center, which utilizes AI data mining and advanced metrics to detect suspicious activity, such as overbilling and shipping materials to non-existent addresses. Now, you probably, if you work in this space or advise in this space, recall that under the past administration, there was a lot of talk about big data at the Department of Justice and using data to make cases or pick out suspicious patterns, in particular in bills that were going to the government, right? So healthcare is the most obvious example because the government pays out such a large amount of its dollars in healthcare dollars. The government has a lot of data as to what claims are being submitted to it in order to pay those claims out. And there have been, for a number of years, lists of outlier billers, billers who are in the top 10 in a certain category or for a certain code in the healthcare industry. But this goes a step further, right? Because this healthcare fraud data fusion center that was announced actually is going to have all of that data centralized. And instead of just sort of top 10 lists or an agent sort of poring over different codes to figure out if anyone's an outlier on the charts, AI is going to do that analysis and flag suspicious activity. And it may not rely on simply who is the highest biller of a certain code in a way that's outsized. It may rely on patterns of activity that are subtler, which I think will aid in the department's work. The Federal Bureau of Investigation, the FBI, has confirmed that it also is using AI tools to detect criminal activity and, in particular, national security threats. So the FBI is using AI to sift through huge amounts of data. And they confirmed that yet again in January of this year. And that presents, again, a further step in the direction of sort of AI being run on large data sets without the need for constant investigator involvement, which, as the federal government goes through, rounds of budget savings or cuts in federal employees, you might think that would naturally lead to decreased enforcement risk. But here, I think they're trying to make up ground by embracing the use of technology in the form of AI to do that data analysis in a way that might be helpful as they lose agents. Next slide, please.
Awesome. So 2 more fun AI enforcement tool examples. First, the Treasury Department announced that its Payment Integrity Office prevented and recovered over $4 billion in fraudulent and improper payments in fiscal year 2024 through its use of enhanced fraud detection processes, namely machine learning AI. So more specifically, through initiatives such as AI expedited check fraud identification, the Treasury Department recovered $1 billion in fraudulent payments and stated that its AI-enabled risk-based screening processes prevented another $2.5 billion in improper payments. So the $4 billion figure is significant and established a new high watermark for the Treasury Department, which shows that this kind of AI-driven fraud detection is unlikely to go away, regardless of what administration's in office. Next, in August of 2025, the SEC created its AI task force, which will utilize, thank you, and enhance the efficiency of accuracy in its investigations through the use of AI and generally signaled a more proactive posture with regard to the use of AI. The SEC AI task force means that securities investigations will increasingly be initiated and supported by AI-detected anomalies in market data, disclosure filings, trading activity. And in short, the government's now essentially an AI-powered investigator, and compliance programs should be designed with the assumption that AI-driven regulators will find anomalies that manual oversight may have missed in the past. And so controls need to be at least as sophisticated as the tools used to detect them. I think it's over to Jen.
So we're going to be into the next slide. We're going to pivot a little bit. We've kind of talked about the way in which AI was investigated under the Biden administration, the way it's being investigated, but also supported under the Trump administration, and the ways in which the government is utilizing artificial intelligence in the enforcement space. We want to talk about the way we're all using artificial intelligence as we defend against these investigations and defend against these cases. And I don't just mean using artificial intelligence to help write briefs. There's lots of cases right now about lawyers being criticized for not disclosing they've used artificial intelligence in court filings. We're going to talk about the attorney-client privilege and work product doctrine because there's breaking news in this space. The first 2 cases at the federal level relating to the use of artificial intelligence, and these 2 doctrines have come out, and we think it's important that we all pay attention to them. And they're also important because they feed into advice we're going to give you about building a compliance framework. So you need to understand how to obtain privilege over work product in your communications with clients, and companies need to understand that so they build robust compliance systems to protect those privileges. So just to remind us of what these are, The attorney-client privilege obviously protects, one, communications between a client and the attorney, and in some circumstances, people who are assisting the attorney. Notice I said people. We'll come back to that in a minute. Two, it's intended to be and is in fact kept confidential. So you haven't intentionally disclosed the information to your adversary, for example. And third, it's for the purposes of obtaining legal advice. The reason that you are having the communication is either to get legal advice from the person you are speaking with or to utilize in seeking legal advice from counsel. That's the attorney-client privilege. Work product doctrine, slightly different, governed right by the rules of evidence. And you have three standards here too. One is the materials. There have to be documents or tangible things. They have to be prepared in anticipation of litigation. There's lots of case law on what that means to anticipate litigation. There has to be a real genuine threat. And three, it has to be prepared by or for a party or its representative. So it has to be prepared by someone who's representing themselves, or it has to be prepared by counsel in anticipation of litigation. So super familiar test to all of us, but in the world of AI, when now we're asking ChatGPT and Claude and Legora and Vincent and name your AI tool, legal questions, are those covered? So let's look at the first two cases. I'll talk about one, and then Matt will talk about the second, and then Matt will compare and contrast them. So we can go to the next slide. So the first case we're going to talk about is United States versus Hepner. This is a case that came out of the Southern District of New York Federal Court that was written by Judge Rakoff. Judge Rakoff ruled on this case very quickly, we think a little bit in part so that he could be at the leading edge of the conversation about how these doctrines work. And at the end of the day, what he held is that documents that Mr. Hepner, who is a criminal defendant, produced using a publicly available generative AI tool, Claude, were not protected either by the attorney-client privilege or by the work product doctrine. The basic facts are these: that Mr. Hepner was a criminal defendant. He's a former financial services executive. He had received a grand jury subpoena, so he was aware that he was under investigation, and he was later indicted for federal securities fraud and for wire fraud. While he was under indictment and before he was arrested by the FBI, he used Claude to develop and outline defense strategies and to assist in discussions with his attorneys. He essentially went to Claude, asked it some questions, and then the answers that Claude gave him, he shared with his counsel after he had received the grand jury subpoena. When the FBI raided his home and ultimately arrested him, they seized 31 documents that memorialized his communications with Claude. The government moved to admit those into evidence. The defense opposed, arguing that they were covered both by the attorney-client privilege and by the attorney work product. We can turn to the next slide. Judge Rakoff ruled against Mr. Hepner on both counts. He did so in a bench ruling first, and then he followed with a written opinion. I would commend everybody to read it, or you're welcome to go to Cleary Gottlieb's website and read the article that Matt and I wrote summarizing this. But on the attorney-client privilege, he said, no go. One, generative AI tools are not lawyers. Goes back to my point. It's not a person. It's not a human. And Rakoff emphasized that AI tools are not bound by fiduciary duties that are owed to clients, and there's no quote unquote trusting human relationship. So he said it failed at that very first prong. A chatbot is not your lawyer. Second, he said it has to be intended to be and in fact kept confidential. And here, unfortunately, Cloud's user privacy policy explicitly states that the parent company reserves the right to disclose your inputs, meaning the questions you ask, and the outputs, so the information that the AI tool gives you for training purposes, and to give to other third parties, including potentially government regulators, meaning that if a subpoena from the government is given to Claude for your inquiries and the output from your inquiries, the government will turn it over. The court also cited a prior case in Ray OpenAI, which is actually an intellectual property case which in that case, the court had observed that AI users do not have a substantial privacy interest in their communications on publicly available AI platforms. I emphasize publicly available because we're not talking about a closed source AI system that many of our law firms and companies have, right? That is not public, it's private. And third, he said it wasn't for purposes of obtaining legal advice. The court found that the defendant, Mr. Heppner, had communicated with the AI tool for the purpose of discussing his case with counsel, and the court recognized that some AI tools may function as highly trained experts and can kind of be an agent of a lawyer, but it said that when you share non-privileged communications with counsel, that doesn't make them privileged, and that is just black letter law. You can't cloak a non-privileged document and privilege just by turning it over to your lawyers. So Mr. Heppner's communications with AI and the output were not privileged in the first instance, and by giving them to his counsel to assist his counsel in providing them an advice, it did not cloak them in privilege. So I want to turn it over, Matt, to now talk about another decision that came out of a different court in a different context in the space of AI and privilege.
Thanks, Jen. So in Warner versus Gilbarco, the Eastern District of Michigan held that what could be viewed as similar conduct was protected by privilege. And I just want to break it down a little bit to get into some of the nuances. So in Warner, there was a pro se plaintiff, Ms. Warner, who was suing her employer for race-based discrimination. Her employer, during discovery, demanded that the plaintiff turn over her entries into ChatGPT and notes from and logs from those interactions. Interestingly, the plaintiff was pro se, so that sort of complicates the analysis here. But the pro se plaintiff resisted and cited the Federal Rules of Civil Procedure, which protect work product, citing the rule that in particular protects documents and tangible things that are prepared in anticipation of litigation or for trial by another party or its representative, citing that rule and saying, I'm a party and I use this tool in preparation and anticipation of litigation. The court, Magistrate Judge Patty, held that the pro se plaintiff's ChatGPT queries and AI responses were protected by the work product doctrine, finding that those logs and entries actually reflected the litigants, the parties' mental impressions and thought processes, and therefore were protected by the rule. The court rejected the defendant's request for a production of all of these materials. So what you see here is, you see within a week of each other in February of 2026, two federal courts, looking at similar fact patterns, right? Not the same, they have important differences, but similar fact patterns, which is when a litigant or defendant used an AI chatbot or service in connection with litigation and reaching quite different conclusions on whether the underlying material is protected by privileged. So overall point, and I'm going to get to some of the differences between the two cases that sort of directed the outcome, but overall point is stay very attuned to this space, because I suspect that there will be many more cases fleshing out these uncertainties and these nuances in ways that will add to all of our understanding of the law, because this is just the first salvo. Next slide, please. So some of the differences between these two opinions, the Heppner case that Jen discussed, and then the Warner versus Gilbarco case that I just mentioned. In Heppner, the reasoning was that the work product doctrine was not intended to shield materials where they ended up in the attorney's possession, as Jen mentioned, but they weren't prepared by the attorney or their agent or at counsel's direction. And therefore, use of this third-party tool, this AI tool, was, did not mean that it was protected by privilege. The reasoning in Warner was slightly different, which is, that the chat logs, as I mentioned, reflected the pro se litigants' mental impressions, and as the party, reflected the thought processes in anticipation of litigation. And importantly, I think, and in a different sort of mode of reasoning, recognize that Gen AI tools like ChatGPT are tools of a litigant and are not actually third-party services or another party. And you may see more and more teasing out of the differences there as courts grapple with this, because as Jen mentioned, of course, law firms or many large companies that have enterprise level agreements or terms and conditions with AI companies that restrict access to and reflect confidentiality of information that's entered into the AI tool are obviously differently situated than the public facing tools. But even the public facing tools, judges may end up looking at them slightly differently depending on the fact pattern. Next slide, please.
Matt, could I just weigh in on that for 1 second?
Please.
I would just add to kind of sum up that when a court considers whether the attorney-client privilege or the work product doctrine cover communications or documents and tangible things, it has always been a facts and circumstances test.
Yeah.
Right? Those cases and those decisions are almost always restricted to the facts that are before the court and serve minimal precedential value, especially at the district court level. And so I would encourage everyone to keep that in mind as they're thinking about these cases. Like, this is not breaking any new ground. The framework the court is using is the framework courts have always used. It's just applying them to the very unique facts and circumstances of using artificial intelligence.
I totally agree with Jen's point. And one additional point would be, you also have to look at the consequences for access to justice that second decision might have had if it had gone the other way, right? So I think that there was probably some concern on the part of the judge who was facing that motion that if the judge did not allow a pro se litigant to use AI tools that were publicly available, it would have a pretty dramatic effect on future litigants and the relative fairness versus unfairness of pro se litigants having access to, some of the same tools that litigants who are represented have. So I think that also might have played a role in the difference. So we wanted to finish today with building a compliance framework and just sort of some very practical steps to think through when you're advising a client on how to put together a compliance program that really accounts for the growth in AI use and adoption, or if you're in-house, how you're designing it yourself. And this is something that we talk to folks about quite a bit. And so I think we had just some practical advice. If you could turn to the next slide, please. So this is modeled as something of a checklist, but of course, each of these categories in and of themselves have whole checklists that you'll want to think through. But we just wanted to flag sort of big picture, what are things that companies should be thinking about, in-house teams should be thinking about, outside counsel should be thinking about in advising companies in how to build compliance systems that can tackle this area. So the first thing we wanted to mention is third-party risk management. When engaging vendors that provide or use AI systems, it's important to apply the same compliance framework that you might apply to your own internal use. So you want to ask about their AI inventory, their risk assessments, to the extent they have policies, procedures, and training that they're willing to share with you. Making sure that there's some human oversight to those systems, because third-party AI exposure may end up being your exposure if they're an important part of your business as well. And so it could present an underappreciated area of organizational risk. The second thing we wanted to flag is, we think a starting place for most businesses and the compliance function is to just take an inventory of what the AI use is at your business, and figure out, the systems that might be used. You can't really build a compliance framework in the modern age, in the AI era, unless you know what your employers are using, what folks in the business are using, and therefore inventorying the AI tools that you use. Are they enterprise grade? Are employees using public AI tools? That can be important to your business and important to assessing third-party vendors' products and services as well. Next, you want to understand potential risks. So for each AI system that you identify in an inventory, you want to think through whether you can conduct diligence that addresses key threats to the business. Has the system ever been used as a vehicle for fraud, or has that business or that type of AI ever been the subject of AI washing claims? How secure is the system against being compromised or exploited? Figuring out whether the AI tool you're using or that a third-party vendor is using has security that would match your expectations for your own systems is really critically important, because these systems are developing so quickly and being deployed so quickly that security has to be at the forefront of folks' thoughts when they're coming up with a compliance framework. In terms of human oversight, you want to make sure that real people are involved at some point in overseeing AI systems and are building controls for its use, particularly if you've identified risks in the previous step. Human oversight is a really important part of the compliance function, even as compliance teams understandably want to and do reasonably employ more and more AI tools to help their work. At the end of the day, human oversight really can't be replaced. And then, the last two things I wanted to mention would be to establish policies, procedures, and training. A compliance program really requires written policies that cover both appropriate and inappropriate use of every AI system and tool you've identified, paired with some meaningful training, so that employees know the rules of the road, paying particular attention to the limitations that might apply to the permissible use of the system. In particular, are employees sharing confidential business information with AI systems, or potentially privileged information outside of those enterprise level agreements that Jen mentioned earlier? That's worth flagging as something you want a written policy on, you want to conduct training on, and have procedures when something goes awry or something is noticed. And then the last thing is to ensure that your external representations about AI use are consistent with all of the things we just said, with your inventory and your risk assessments, right? Because when you're talking to investors, to clients, to regulators, to the public about how you as a business use AI, you've seen some of the potential pratfalls in what we just discussed in overstating AI use. But you want to also accurately disclose AI use to the extent it's not publicly known if you're talking to investors. So thinking through an accurate and consistent message across different stakeholders, modulated to account for the risks that you've identified, I think is really important, because misalignment between what you say and what you're actually using, or the capabilities of the technology, may increase your exposure. So happy to, I don't see any open questions in the chat, and we are exactly at time. So I want to thank everyone for tuning in, and thank you very much to the Beverly Hills Bar Association for having us. It was a pleasure speaking with you today. And I know I speak for Jen and Christian when I say thanks for tuning in.